All right, thank you very much, Oyoyemi Ajayi, for those excerpts from the first two editions of Good Morning Nigeria, during which we focused on the issue of autonomy for the state judiciary and state legislature. Of course, the key points there that were highlighted are matters that are still alive. And so we return to the subject matter today. And with us in the studios this morning, here in Abuja, I would like to welcome the Attorney General of the Federation and Honorable Minister of Justice, Abubakar Malami, learned senior advocate of Nigeria. Pleasure to have you on Good Morning Nigeria. Okay. And also being part of this conversation this morning from our Enugu studios, a regular guest on Good Morning Nigeria, would like to welcome Professor of Constitutional Law, that's Professor Race Achara, former Dean of Law at Enugu State University of Technology. Professor Achara, pleasure to have you this morning.
Yeah, thank you very much.
Okay, let's begin the conversation with the Honorable Minister of Justice. Honorable Minister, it is 1 year this month since President Muhammadu Buhari signed Executive Order number 10 of 2020, which was intended to kick off the full implementation of the provisions of the Constitution, as well as the court order guaranteeing and granting autonomy to the judiciary and the legislature at the state level. The Presidential Implementation Committee was also part of that Executive Order 10, of which you are chairman. But here we are, 1 year later, it is still a debate as to whether the states can implement it, if there is a framework, or otherwise. What is happening?
Well, I think, generally speaking, operation, application, and enforcement of laws is a process. With particular regard to the executive order, you have to take into account the antecedents. One, there exists in place constitutional amendment with particular regard to Section 121, subsection 3 of the Constitution. That initiated the process. Arising from constitutional amendment, we equally have in place Executive Order number 10, signed by the President, which in effect is designed and intended to give enforcement spirit to the autonomy as contained in Section 121, subsection 3. Arising therefrom, there were contentions, particularly on the part of the governors, as to the application and operation of the provision of Section 121, subsection 3 and the executive order. And you have, in that respect, an implementation committee, among others. And there have been, arising from the implementation committee, series of engagements which are ongoing. So I think, as a process, we are evolving. Nobody is contending about the constitutional amendment having been in place. Nobody is equally contending about the need for the executive order. Nobody is contending about the fact that there exists a political will on the part of the executive, in particular the president, about the implementation of the autonomy of the judiciary and indeed the legislature. But then perhaps the limited engagement is about modalities. So I think, again, the background of these processes that are unfolding, I think the process is indeed evolving, and we are certainly getting there. At the end of the day, the executive order has been in place. The legislative processes associated with its implementation are in place. And I think the engagement is a product of such process that will eventually see to the implementation, enforcement, and application of the executive order. To what extent and in which direction and modalities is what is being contended, is what is being engaged upon among the contending parties of interest and stakeholders.
Okay, under a federal system of government, how workable is the financial autonomy of the judiciary?
Well, how workable it is has been established by an existing arrangement that obtains at the federal level. As you rightly know, the federal government has granted financial autonomy to federal judiciary, and as a first-line charge, the budget allocation of the federal judiciary is being directly deducted from the consolidated revenue fund as a first-line charge. So again, the background of its workability at the federal level, it goes without saying that it is indeed a workable arrangement as far as the state level is concerned. Autonomy of the judiciary, autonomy of the legislature is a constitutional function. In fact, the executive at the federal level, the executive at the state level, the judiciary at the federal level, the judiciary at the state level, legislature at the federal level, legislature at the state level are all products of a constitutional order. So again, the background of the fact that they are institutions that drives their authority from the Constitution, it is inevitable that the law, the constitutional amendment, the executive order must naturally come to pass against the background of its workability at the federal level. So since it applies, operates, and then become enforceable at the federal level, I do not see anything stopping it from being operated, being enforced, and being applied at the state level, particularly against the background of the constitutional sanctity of the autonomy that has been established and enshrined in our Constitution.
Well, Attorney General of the Federation, the state governments have raised one critical issue, and without prejudice to their ongoing engagements with the stakeholders on how to implement the autonomy, it's necessary to interrogate the arguments that they have raised, and which concerns actually part of the challenges that they say we face with our operation of federalism. They argue that, look, the National Judicial Council is responsible for the payment of judicial officers, and that there are provisions in the Constitution which empower the federal government at this time to take care of the judiciary, but that on their own, they have been taking care of both recurrent and capital projects, including the building of courtrooms, building of quarters for judges and all that. So it's sometimes to an outsider, this sounds like a fuzzy argument. On the one hand, you say, oh, the federal government takes care of the pay, that's through the National Judicial Council, of the pay of judicial officers for courts of superior jurisdiction or superior courts, that's to say Federal High Court, Customary Court of Appeal, as well as Sharia Court of Appeal, but that they have also been taking care of this, and that if you were now to grant full autonomy, it's going to affect their own resources. How clarify this issue for us, assuming that this is one of the issues you are still focusing on?
Well, the fact remains that there are constitutional amendments, or perhaps constitutional provisions establishing rights, responsibilities, liabilities, and assets within the context of the autonomy. So the fact cannot be taken away that responsibilities, both of the federal and the state governments, as far as the judiciary and state legislatures are concerned, are constitutional, legislative, and statutory. So within the context of the constitutional order, within the context of legislative arrangement, and indeed the context of statutory arrangements, what are the rights, powers, liabilities, responsibilities that are expected of the state? So you cannot take away, neither can you displace the argument that there are corresponding financial rights and liabilities within the context of the Constitution, existing legislative framework, and indeed existing statutory provisions as far as the running of the judiciary at the state and federal level is concerned. So the simple question is, are there rights? Are there financial responsibilities, financial obligations on the part of the state governments? If the answer is yes, what are they? And then within the context of appreciation of what rights, privileges and obligations exist. The law comes into place. Provide, make provision, because it is all about authority, constitutional authority. It is all about efficiency of the system. It is indeed about strengthening the institutions that will translate to efficiency in democratic system and processes. So the simple issue is not about who is responsible for what, but whether within the context of your responsibility you have indeed provided efficiently for the system to operate efficiently and indeed strengthen the existing democratic institutions. So you cannot take away the fact that there are financial responsibilities, financial rights, both on the part of the federal and on the part of the state. So the issue is whether the system arising from the constitutional provision can allow the states to shy away from their financial responsibilities as established constitutionally, as established through the existing legal framework, as established statutorily. That is the question. If the answer is yes, they provide. I think the contention is about whether the states are ready to provide or they are not. And our position is the states have financial responsibility within to the state legislature, to the state judiciary, within the context of the Constitution, within the context of existing legal framework, and within indeed the context of statutory provisions prevailing both at the state and the federal level. And is what they are now being called upon to ensure the implementation, so that the state legislature, state judiciary can be strengthened. The independence required, both financial and otherwise, can now be deepened for our democracy to strive efficiently and effectively.
So if the Constitution gives the legislature and the judiciary everything you've outlined there under the Constitution, why do we need the Executive Order 10?
The Executive Order number 10 is necessary because in normal course of business, for example, you have a law in existence, but the application, enforcement and operation of the law is a function of certain statutory bodies. I talk of statutory provisions and legal framework, for example. You now say NTA should be given as a budget item 1 billion naira, for example, is stated in the Constitution. Don't you require, for example, the Ministry of Finance to release 1 billion naira to NTA?
I do.
So that is where the executive order comes into place, to support the existing legal framework, constitutional framework to function, to ensure at the end of the day that what has been statutorily, constitutionally, and sanctioned by a legal framework comes to pass through the administrative process. So it is a complementary arrangement that will see to the execution of a statutory right. A right is established, the process associated with the investiture of the right calls for certain institutional support. Perhaps the Office of the Accountant General, perhaps the associated existing institutional arrangement that will see to it. If you have to go to the farm, you have the farm, quite all right. You want to engage in agriculture, it is only natural that you look for a laborer to perhaps farm and tilt the land for you. The land, existence of the land in its own right does not make you a farmer. It's what you do to ensure at the end of the day that farming processes associated with plantation, harvesting, and associated issues are done. That is what makes you a farmer. So you have the law, but what do you do by way of providing the institutional support to make the law enforceable? If you have EFCC, for example, as an institution of government that is vested with responsibility of investigating financial crimes, for example, economic crimes, for example, it is only logical that EFCC will embark. You have the law establishing the EFCC. You have offenses established by law. But then the act of investigating, prosecuting, arraignment, and perhaps judicial determination are associated and incidental processes that will give effect to the law. So executive order is indeed an order that is intended to give effect to the operation, enforcement, and application of the law.
All right. Thank you very much, Leonard, Senior Advocate and Honorable Minister of Justice. We're going to pause here and then go over to Professor Reyes Achara in our Enugu Network Studios. We earlier introduced him. Professor Reyes Achara, what do you make of the ongoing arguments and, of course, as the Honorable Minister has told us, the processes to implement full autonomy for the judiciary and legislature at the state level? Is this a storm in a teacup?
I think the major problem is in a conflation of terms and a slight misunderstanding of the basic constitutional structure for financial allocation to the judiciary and thereby granting it autonomy. The conflation comes in the fact that there are different heads of expenditure. And the problem that has given rise, that has triggered the strikes of the Judiciary Staff Union of Nigeria and some of the arguments from the Nigerian Bar Association and the various governments at the federal and the state levels consists in the fact that they have not made the proper nuancing between expenditures that concern personal remunerations of judges as opposed to remunerations of their support staff. On one hand, capital expenditures that deal with the running of the courts, quite apart from the personal remunerations of the judges and the staff. These are areas that have not been properly considered and distinguished, and that has led to a lot of problems. But the Constitution has been clear about these distinctions and nuances. You see, the first is for us to understand the structure of allocations. There are three pots, common pots. There's the federation account. This is a common pot that does not deal with allocation, that does not deal with spending. It's a notional pot that deals with the revenues that come into the federation. Who is entitled to these revenues? And Section 162, subsection 3 and 4, show that these revenues are shared only between tiers of government. It does not deal with arms of government. It is vertical, not horizontal. What we mean by this is that the federation account is something to be distributed between the federal government on one hand, the state governments on the other hand, and when this thing is sent to the state governments, to a central pot that also allows the state government to redistribute it also to the local governments. It does not deal with the tiers of government, that is to say, the executive arm of government, the legislative arm of government, and the judicial arm of government. So it was a misnomer for Section 162, subsection 9, to provide that any amount standing to the credit of the judiciary shall be paid directly to the National Judicial Council. The Supreme Court has had occasion to deal with this matter, and many of the combatants, both at the federal level and at the state level, seem to have omitted this. They've forgotten that this matter was dealt with as far back as 2002 in the resource control case. Attorney General of Abia State versus Attorney General of the Federation. In that case, the Supreme Court clearly stated that there is no sharing, that there's no amount that stands to the credit of the judiciary in the federation account. So let's get that off our minds. Then there's these other two accounts. The Consolidated Revenue Fund of the Federation. That's the purse, the wallet that is due to the federal government. Then there's another wallet that is due to each of the state governments. It's called the Consolidated Revenue Fund of the states. It is monies that come from that federation account that are channeled to these pots. It is these funds that then decide on distribution, how these monies will be spent. And that is where monies can come to the services that each of the spheres of government will carry on, whether it's at the federal level, for the federal courts, for the federal executive, for the federal legislature, and for us, the employers of all these three arms. And this is what people get confused. The government is not being run for the agencies of government. The executive, the legislature, the judiciary, they are just our servants. They are acting as if these monies are supposed to be shared between them. It's for us, the citizens. They are our workers. We then use monies and give our workers and say, okay, we are going to give you this amount to do this service for us. But we've changed everything. In Nigeria, I don't know, we keep turning things upside down. So it is that purse that the federal government deals with. And that is the purse that can then get allocations for the different arms. The same thing applies at the state level. Now, this is the important part that has caused a lot of difficulties. When these monies come to the purse of the federal government, which is Consolidated Revenue Fund of the Federation, and the purse of the state government, which is the Consolidated Revenue Fund of the state government, the Constitution says, look at what things should be charged to each of these purses. Anything that is charged is what we refer to as first line item, charges to the Constitution. That is, it is not something that is subject to debate. Once it is charged, that amount is to be paid first before we then, the balance that is remaining, we will now distribute it to whether we are going to drink water, we are going to have electricity, we are going to have NTA and its staff. But those charges, the Consolidated Revenue Fund of the Federation, there's a specific requirement that salaries of the judiciary that are stated in Section 6, because the judges there, from the High Court upwards, are to be charged significantly, remarkably, peculiar. They are to be charged, their salaries, their remunerations, and they are working, their recurrent expenditures for maintaining their costs. These are to be charged to the federal government. This is strange, but it's important that we note it, because our Constitution is peculiar in how it distributes powers and responsibilities. It made it clear that all these amounts will be charged to the federal, not the states. So when you're talking about payment of salaries of judges of high court, which is a state court, you are going to have to bring it from the federal Consolidated Revenue Fund of the Federation. And that is why they have power to determine on appointments. That's why the NJC, which is somewhat federal, has a say in whether or not they are going to create offices of judges in states, because they have responsibility to pay. Now, it's a different cup of tea entirely from capital expenditure. These ones are not charges, whether at the Consolidated Revenue Fund of the Federation or Consolidated Revenue Fund of the states. It's not a charge, but it's a responsibility, which by the normal process of budgeting, you will find out the needs, you will find out what is required, and this thing is budgeted. And when it is budgeted, it stands to the credit of the judiciary for that year. And all these amounts, when they have been determined, will now be paid, if it's at the federal level, first to the National Judicial Council, which will then subsequently distribute it to heads of courts. And if it's at the states, which deals with courts that are not created under Section 6, that includes area courts, magistrate courts, customary courts, these lower inferior courts. These are the responsibilities of the states, and if it's at the FCT, of the federal government. But when you're dealing with the courts that are superior courts of record sector by Section 6, all their recurrent expenditures to maintain their courts, and all the salaries and emoluments of those judges, these are things that are charged to the federal government. So the problem that has triggered this strike is a misunderstanding of this. There are two things that principally have triggered the misconception. One is the issue of who should pay, and that's what I've explained now. The other is, when is the payment to be made? Is it to be given in bulk, as happens at the federal level, where the legislature keeps on getting 150 billion every year, without regard to competing needs of the citizens? If there are no roads, we are still going to give National Assembly of 469 persons the budget of 150 billion, regardless of education, regardless of roads. So what we are saying is that these are the issues that people should bear in mind, and when we bear it in mind, it's easier for us to then come to a conclusion. And that's why the just strike, in my respectful submission, seems a bit misplaced, misunderstood. Everybody agrees that there's need for autonomy of the judiciary, but this is not the way to go about it, by breaching our constitution. We should not also, by way of executive orders, purport to impose on state officers from the federal level what the constitution does not allow. Section 160, subsection 2, gives an example of what the attitude the constitution takes to an imposition of powers or responsibilities by a federal body to a state body without the consent of each state governor. The constitution says you should not, as a federal executive body, impose any duties or responsibilities on state officials or authorities. And that is what Executive Order 10 of 2020 purports to do, and that will be unconstitutional. Let me stop at this point. I could develop the arguments as we go on.
Well, Professor Reconciling, I would like you to clarify this just before we come back again to Abuja studios. There is the point, you're talking about the conflation of the constitutional provisions and then the operational aspect. Earlier you said, look, and that is true, that the federal government takes care of the emoluments of judicial officers itemized in Section 6, that's to say judges of superior courts of record, from High Court and above. But the cost of their support staff is not part of the federal government's responsibility. How do we reconcile this aspect? And then how do we also bring in the fact that capital items are ordinarily supposed to be state responsibilities? Capital items, one, and then two, payment of support staff, which is very critical. Part of the argument that has been made over time is that a number of judicial officers have been constrained by the absence of capital items, and that they have to go cap in hand to the state chief executives to procure these items, and oftentimes in humiliating circumstances. And that in some instances it's alleged it becomes one of quid pro quo. So if that is the issue, to say, look, let state governments recognize that they will take care of capital items, and then capital items including vehicles, quarters, and offices, and then the recurrent expenditure for the judicial support staff. Why are we still having this contention with full autonomy for the state judiciary as an example?
The very point we were making. Once we distinguish what the Constitution provides for, we can then move on to what could help make things better. But let's know the minimum requirement. What does the Constitution provide for? The Constitution does not provide for capital expenditure as a first-line charge. That's the point I'm trying to clarify here. There are some people whose payments, policemen and all that, important people, fire services, water, everybody who is an official does work, important work for the federal or state governments. But they are not necessarily first-line charges. That's the point I'm trying to emphasize. These things are not first-line charges. Does not mean that the legislature does not have power to make appropriations for those things. So, and there are examples from all over the world. We're acting as if this is, Nigeria is the first sovereignty in the world, and all these problems are arising as a novelty. It's not novel. In all the jurisdictions assessed by a paper by Rosselli in 2020, Indiana Journal of Constitutional Systems. Rosselli found out that only 2 countries of the world, Bolivia or Honduras, have as a preset provision that the judiciary will have a percentage of the overall budget or revenues of the government in each year. 3% in Honduras, 4% in Nicaragua. But these are not necessarily the best models we can adopt. United States, United Kingdom don't have such a thing. You do not just take a percentage of our budget, whether or not it is needed in a particular year, you give it to just one branch of government, while the rest of us, 200 million Nigerians, will now be suffering. So you have to balance about ensuring autonomy for the judiciary and also ensuring that the citizens get their dues. You have to make that balance, and that balance has been made by our constitution by saying the ones we are afraid of that could cause a judge perhaps to have a worry about the decision he will give in court is the one that deals with his personal salary, the one that deals with his recurrent expenditure. So if the court is already set up last year and there was a requirement for papers, for computer stationery, for fuel for his car, all those things are recurrent. Those are things that are charged. But the things that, like building a new courthouse, is a capital expenditure. You have to wait to balance it with other needs of the citizens. Government and its agencies are appropriating things in a way that disregards the interests of citizens. And that's one thing that nobody is speaking on behalf of the citizens generally on this point. And the issue of going cap in hand is something that is a misplaced concretion with the greatest respect. First of all, why do the judges need to go cap in hand to beg? There are executives that are already in the judicial system who are under the courts. For example, in a high court, there's a chief registrar. Why should a chief judge go to start talking about his budget in the governor's office? In any case, it's not even the governor that should be the one addressed, because they are offices of budget. So when these things have been already put in place, there's the legislature. Our constitution says you must not give anything out unless the legislature authorizes it. So if the legislature has already passed a budget, the issue now will be the time of disbursement. And that's the area that we should be concentrating our minds. But unfortunately, we've been conflating a lot of issues. The issue of remuneration, RML and fiscal, that's the Revenue Mobilization, Allocation and Fiscal Committee, is the body that states the upper limits and the lower limits. And these limits cannot be changed in respect of people like the judiciary. Once they say this is the salary you're entitled to, it cannot be changed subsequently. So without amendment of the Constitution. So what we have now is a position where if you have already established the salaries of judges, you've established their emoluments, which include car allowances. They are just officers like every other person. They are not entitled to extra expenses. So what is happening here is that the legislature, the executive, when they abuse their powers by allocating too much in terms of luxury cars to themselves, they then give a little to the judiciary. And the judiciary that we have appointed as our guards to guard against such abuse of power now starts collecting the thing, and after a tradition of collecting it for a period of time, they now say, no, you should allow us to start this abuse autonomously. We'll do it by ourselves. Give us the entire money so that we can give ourselves exceedingly luxurious cars and things that may not have been approved for us by the legislature on one hand, or Revenue Mobilization, Allocation and Fiscal Commission. Let us understand these things first. The first is the things that are charged are just revenue. Those are the ones that are first line charge, not capital. Then capital should be exposed to deliberations from the legislature, the executive, and the judiciary, as is done in America. as it's done in the United Kingdom. Why are we changing things?
Okay, thank you so much, Prof. We're now coming back to the Honorable Minister. You've listened to what the Prof has said, and just like him, experts have said the continued dependency of the judiciary and the legislature on the executive is sort of taking away their will to perform effectively.
Well, I think there is a misconception that needs to be cleared with particular regard to the submission of the Prof. And that misconception has to do with the way budget operates. The misconception can best be cleared with particular regard and recourse to the provision of Section 121, subsection 3 of the Constitution. That provision clearly talks of consolidated revenue fund of the federal government and of the state. And the implication and input of that provision is to the effect that the state legislature, state judiciary, will be entitled to their budgetary allocation direct from the consolidated revenue fund. So the implication of that is this: whatever funds stands to the credit of the state, for example, to the consolidated revenue of the state, the budget that should ordinarily be laid before the state legislature by the governor should have a component of a provision for the state judiciary. State judiciary, state legislature will be participants in the act of drawing the budget for the purpose of putting the necessary demands as it relates to capital expenditure, for example, and the supporting staff, for example. And then on the basis of the formation and formulation of the budget is presented to the state as House of Assembly for consideration and passage. If eventually it is passed and 5 billion is allocated and is meant for the state legislature, 2 billion for the state judiciary, that the implication of Section 121, so Section 3, is that the state executive should provide the agreed budget as passed by the state House of Assembly. So that takes away the perhaps hand-in-caps arrangement. That takes away the kind of attitude of subserviency, because a CJ of the state requesting for capital project before now must naturally be seen pleading, soliciting from the state. But if you are now guaranteed and assured of a certain budgetary provision relating to capital expenditure, relating to the supporting staff welfare and associated salaries, the idea of direct engagement with the state by way of solicitations, by way of persuasion, by way of plea for certain capital project provision does not arise. That is the anomaly that the provision of Section 121 seeks to amend. So what I'm trying to, the misconception I am trying to clear, arising from the submission of the prof, is the fact that the budget naturally is intended, arising from the provision of Section 121, to factor the demands, the request of the state legislature and judiciary, and when it is agreed upon as forming part of the budget, they are now entitled to it as a matter of right and no longer as a matter of privilege. The arrangement that obtains on the ground now, before now, was an arrangement whereby it is at the pleasure of the executive, state executive, to make financial provision in terms of capital expenditure and associated things for the legislature and the judiciary. And the arrangement we are trying to put in place now is to strengthen this institution, for the judiciary now to be able to stand on its own to determine cases efficiently, justifiably, and judiciously without fear or favor, against the background of the fact that I have limited need for engagement with the governor as far as financial provision on capital expenditure, among others, is concerned. So I think that is where the misconception on the part of the FROF arises. The arrangement is that there exists a consolidated revenue fund at the federal and the state level. There exists a consolidated revenue fund at the state level, and then arising therefrom, there is a budgetary provision for the judiciary and the state legislature, and then that budgetary provision is given as a matter of right and no longer as a matter of persuasion or perhaps solicitations. So I think that misconception needs to be cleared on the part of FROF. There exists a budgetary provision, there exists release as of right. That is what is intended by the provision of Section 121, Section 3.
That is to say that, look, in preparing a state budget, the budget of the judiciary will also have been prepared. The budget of the legislature will also have been prepared. And all of these form components of the state's draft appropriation, which is then taken to the state legislature, and once passed, it becomes a law. And the law is that it must be obeyed in tandem with the provisions of Section 121, subsection 3, which is to say, for the judiciary, give what is due to it. For the legislature, give what is due to it. Professor Ray Sachara makes the point that the chief judge doesn't have to go to the governor, that there is a chief registrar. Yes, there's a chief registrar, but perhaps you give us some examples of the chief registrar who goes with the file to the governor and then gets approval from time to time. I'm sure you've heard of the issues that we're dealing with. In some cases, some governors have been referred to as emperors. But state governments, of course, have also complained about their financial straits. And I'm sure, Attorney General, you listened to the excerpts of one of our earlier conversations. Professor Akinseye George was making a recommendation with regard to say, right, in tandem also with the provisions of the Constitution, which stipulate grants in aid in deserving circumstances, that for the takeoff of this autonomy, perhaps the federal government could say, fine, we will supplement state governments with some grant of, say, 50 billion or any amount that the Accountant General and the Minister of Finance would say is reasonable. And then going forward, we then begin to work out the modalities for efficient funding of the judiciary and the state legislatures. What is your reaction to that recommendation?
Well, when you talk of a right, I don't think the privilege, a privilege, has a place to stand upon. We are talking of a constitutional right. Constitutional right enshrined in the Constitution. Constitutional right vested in the state legislature. Constitutional right vested in the state judiciary. And you are fighting to have the right. So when you are struggling to have your right established, the sanctity of the right is what you are fighting for. Talking of a privilege is in effect diversionary. So my take on it is a constitutional right has been established as it relates to budgetary provision and allocation for the state and legislature. The starting point is to establish and ensure the enforcement of that right, and any other thing can follow. When someone is indebted to you, for example, and then perhaps you are claiming from a person or for 1 million naira from him, does it make any sense avoiding the claim and pursuing a handout? It doesn't make sense. So the idea of perhaps take-off grant or no take-off grant is an issue that is not that is extraneous. You understand what I'm talking about? Mm-hmm. So the inherent issue is the right. Let us fight for the right. I think the federal government has established a tradition of supporting institutions over time. You may very well remember perhaps maybe a 10 billion bailout funds that were provided for the states over time, among others, and periodic support by the federal government. But all these things are indeed supportive gestures on the part of the federal government to assist the institutions to fulfill and meet up their obligations. So in as much as I agree that the possibility of certain grants could be there, But I think the idea of grants is diversionary as far as the application, operation, and enforcement of the constitutional rights guaranteed for the state legislature, the state judiciary within the context of the autonomy is concerned.
Okay, Honorable Minister.
I know, Juma, you want to sign him off. Yes. Honorable Minister, we have no time again. We are pressed, but I was just wondering, what is the latest on P&ID?
Well, the latest on P&ID is the case is slated for final determination. But as you rightly know, we have recorded a lot of successes, particularly as it relates to the proof of fraud and perhaps maybe corruption and associated issues that gave rise to reconsideration of the case that afforded us an opportunity for the case to be revisited. So within that context now, the idea of perhaps maybe arguing fraud, the idea of arguing corruption associated with the contract in its own right had now been accommodated as a component of the case for us to establish and have the case finally determined. And the case is being considered for final determination.
Okay, Honorable Minister, Attorney General of the Federation and Minister of Justice, Abubakar Malami San, thank you so much for your input and clarification on the autonomy of the Judiciary and Legislature. And from our Enugu studio, we're joined by Professor of Constitutional Law and past Dean of Law at Enugu State University, Professor Reyes Achara, SAN. Thank you so much for your contribution to the conversation. We'll take a break now. When we return, we have another topic to discuss.